So if you're looking to make your first hire, stop focusing on finding the right person, because the real problem is that you haven't decided what success looks like for this employee and what you're actually taking on legally, financially, and structurally. So in the next few minutes, I'll walk you through the three primary decisions that every Ontario small business owner needs to make before they make their first, second, or next hire, so that the person they bring on either succeeds on clear terms or you have the legal foundation to make a clean decision when they didn't. And if you want this framework, which I call the First Hire Readiness Framework, just drop employee below and I'll send it right over to you. So my name is Romesh Shakir. I'm the founder of Signal Lawyers, an AI-enhanced law firm, and we help business owners build the right legal infrastructure before problems make it necessary. And in these videos, I want to share with you one piece of advice that can help you make decisions a lot better than you could otherwise. So here's the actual problem. The first few hires in your business could actually be growth milestones. You're excited, the workload is real, and you might even have the right person in front of you. And in that momentum, many small business owners, frankly, too many small business owners, they'll skip the decisions that really determine whether the hire is going to contribute to their business success or alternatively undermine it. Now, what most business owners do, they'll look for an offer template online, or they'll use ChatGPT to create an offer. They'll adjust the compensation and start and send it, or they'll alternatively take someone on as a contractor because it feels simpler and more flexible. Now, they're not trying to cut corners here, but the decisions that they think are administrative could actually have impact for much longer than they could have ever expected. These approaches don't really work because a template or something you get from ChatGPT doesn't really know whether your arrangement is going to be compliant with the Ontario Employment Standards Act. It might not even have the provisions that are going to be right for your business because, again, you don't know what you don't know. You might not have accurately given AI all the information it needs. It might not even know if this person legally qualifies as a contractor, or if they are not legally qualified as a contractor, what are the repercussions? Misclassification is unfortunately one of the most common expensive employment mistakes in small business. And you won't even know it's wrong or not perfect until a dispute happens. And that's really where the First Hire Readiness Framework comes in. There's three decisions that you've got to be thinking about before the contract or the offer goes up. So the first step is classification. Ontario law has specific criteria that determines whether a worker is either an employee or contractor. And generally speaking, it falls down into four categories. So who is exerting control of the work done, whether the worker is working exclusively for the company, whether the worker or the company is providing the tools of employment, whether the person can profit or lose independently. And if you get any of this wrong, you could inherit costly financial obligations retroactively. And you obviously don't want to get into that situation. So the second piece is offer letter, where if this is going to be an employee, the offer letter is going to be a contract. And so as a contract, it needs to satisfy contract law in Ontario. That means that you've got to carefully craft the role, the compensation structure, hours of work, the entitlement to vacation, and perhaps most importantly, a termination clause that's compliant with Ontario law. An offer letter or a contract without a valid termination provision doesn't only leave you exposed, it could mean that if you want to terminate them, you might have to give them notice of the termination for up to 1 month per year worked. So a 5-year employee, you might have to give them 5 months of advance notice of the termination. Again, a really costly and expensive endeavor. Moreover, before the person starts, you also have obligations you can't backfill. So that means like WSIB registration, if you qualify, source deduction set up with the Canada Remedy Agency, even a basic health and safety policy. These aren't necessarily optional, especially the first couple. They are the floor. You have to get this done if they're going to be employees. And then the last thing, which most lawyers don't talk about, but which we do at Signal Lawyers, is you really got to set expectations of success. Now, if a hire doesn't meet expectations, you need a defensible basis to terminate the employee at the lowest possible notice exposure. And under Ontario law, you have a thing called a probationary period, a period in which a business can terminate an employee without paying them any notice. And we recommend that every business have a probationary period for their employees, so that if the employee meets expectations, great. However, if the employee does not meet expectations, you can end the relationship without giving them additional monies. Either way, in order to get a probationary period that's legal, you need to make sure that it's in writing. And so the things that you've got to consider here is that how long the probation period is, what expectations you have for the employee or the worker to satisfy, and then clearly communicate these expectations early enough at the start in writing so that the employee can acknowledge them. I would even recommend it as part of the employment contract. Now, this works because every step is going to protect your business at the moment it matters most. And that's not on day one. It's on the day that the employment and relationship ends. So you've got to make sure that you classify correctly the worker. You've got to make sure you documented the offer properly. And then you have to set the performance conditions in writing. Now, the good news here is that most of what this framework covers is stuff that you can handle yourself. In fact, the only two things you really need to talk to a lawyer about is really the first pieces, the employee classification and the offer letter. Everything else you don't need to talk to a lawyer about. But make sure that when it comes to the offer letter and the classification, you do talk to a lawyer. They're the ones worth getting right. Again, if you want the complete First Hire Readiness Framework covering classification, documentation, obligations, drop employee in the comments below, and I'll send it over to you. You can run through this framework before your next offer goes out, and you'll know exactly which decisions you've made, what documentation you need, and what requires a second set of eyes. The business owners who do this are building a hiring practice that's going to scale with their business. The ones that skip is going to be inheriting really expensive problems every single time they hire.